And joining us again is criminal defense attorney Regina Tsombanakis from Florida. She is a former public defender in Orlando and Broward County. Regina, if this case is not heinous, atrocious, and cruel, where you have multiple shots, boom, 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 one after the other, and people are shot and realize that they are being killed, what is heinous, atrocious, and cruel? Give us an example of what it purely would be, factually speaking, as an aggravator.
Jeffrey Dahmer type of cases, Ted Bundy type of cases. This case is different from those types of cases because Mr. Warren was acting under extreme mental distress, which is a mitigator. That is the difference between those types of cases. You can't, when you think of Jeffrey Dahmer, you think of the torture, of the deliberate skinning of all the different things he did to the victims, and Ted Bundy. It's not the same as Patrick Warren. But for Jonathan Buick coming into their life and his wife moving in across the street, would this have ever happened?
All right, so if we look at this from inside Patrick Warren's head, right, because it is a manslaughter type of heat of passion, according to the defense, why didn't he take the stand? Because he didn't. He never took the stand in this case. Would it made a difference? Now, these are experienced public defenders. They know more than we do behind the scenes of what's going on. But from your vantage point, Regina, do you think that he should have told his story?
I think his story was already told. I don't think he probably would have added anything more to that. I think what should have been harped on a lot more was the fact that he wasn't as controlling as they made him out to be. No man can be that controlling that allows his wife to go cross a few states, bring back a complete stranger, a complete strange man, let him live in his house, give him a job. How controlling can you be? Most husbands would never tolerate a woman bringing a strange man into the home. They would actually want to see, well, where's this daughter of yours? Why isn't she here? Why are we supporting the boyfriend? So these things need to be looked at, and that should have been brought out a lot more, that this man was not in any way, shape, or form going to perform these acts but for the provocation that occurred, but for the extreme distress that he was suffering at the time. And that's what's different from it being heinous, atrocious, and cruel in the sense that the prosecutor is trying to make it out to be.
You know, I noticed in the closing arguments by the defense, they talked about that you are given the obligation as jurors to decide this penalty phase, but also as a recommendation, but also you are godlike. And there was an objection, and they went to the sidebar. Now, you're in Florida. I think one of the finest defense death penalty closings I have ever heard was in Atlanta, Georgia. It was a case I covered for Court TV back many years ago. But it was Ed Garland who made his whole defense closing about God giveth life and God taketh life. And it was a very spiritual close, and the jury recommended life. It was so emotional. Do you ever have that type of a death penalty close in Florida, or is it just sort of, you can't do that?
It's really not allowed, because what you're doing is you're trying to sway the emotions, and that's obvious that you're trying to sway the emotions. Obviously, we try to affect the emotions of the jurors in what we present, but we have to be able to do it with admissible evidence and admissible statements. It's very difficult, because unless you've actually asked everybody of how they feel about God and what their religious views are, you can actually cause problem around if you're not sure and start talking about that. Not that it would be allowed anyway in a Florida courtroom, because that type of argument is just not admissible.
Interesting how the different states vary. Now, in the state of Florida, the jury recommends the sentence, but the judge, when it comes to sentencing, he must give great weight to the jury's recommendation, right?
That's correct, but the judge does not have to follow it if the judge feels that they have reached a decision that he feels is not in line with all the evidence that he's heard. So he has actually the power to change that if he wants. It doesn't happen very often, but he can do that.
He can, and I've seen it done. Also, the deliberation can be shorter in this phase because they don't have to be unanimous. Now, thank you, Regina, very much for joining us.
Sure, thank you.
We're going to jump back inside the courtroom for more.